This courtroom is running hot today. Multiple defendants, multiple cases, and one judge who is not here for games. You're about to see real-time decisions on bond, literacy, addiction treatment, stolen property, and even a defendant who says, "I'm not guilty, so just dismiss it." We've also got a defendant admitting he can't read, another asking for mercy after missing court, and someone begging to get into treatment instead of sitting in jail. Watch how the judge handles all of it, because every ruling today could decide freedom, rehab, or jail time. And heads up, by the end, one ruling changes the entire tone of the room. Who walks out and who stays locked in.
On behalf of Mr. Britton Morris and Mr. Morrison, state your name for the record, please.
My name is Britton Morrison.
Judge, we respectfully request that this matter be set for preliminary examination, please. All discovery is complete to our knowledge.
People, other witnesses available tonight? Preliminary examination in person, September 9th, 2025, 9 a.m. before Judge Bravo.
Thank you, Judge.
Bond continued. You're welcome. Thank you, sir. Thank you. Court does call the cases of the People versus Barrage Ante Scott.
Thank you. Stephanie Cannon on behalf of Mr. Scott. Mr. Scott, please state your name for the record.
Barrage Ante Scott.
Thank you.
Welcome.
And Your Honor, we are asking that all of his cases be set for a preliminary exam.
All discoveries complete on these?
Yes, Your Honor, to my knowledge, all discovery has been completed.
Preliminary examination in person on these matters, September 9th. Would people, other witnesses available tonight?
I would do our utmost best to have them there on September 9th.
September.
We need to talk about what just happened with Mr. Scott. His attorney just told the court he can't read and that he's actively in a literacy program and treatment. That is huge. In criminal court, judges don't just look at charges, they also look at rehabilitation. When a defendant shows they're doing programs, especially education and inpatient treatment, that can influence future sentencing and bond decisions because it signals effort, not defiance. Notice how the judge's entire tone softens. He congratulates him and even admits he already knew about the literacy problem. Question for you watching. Does effort at self-improvement earn leniency? Or is it just damage control once you're already in custody?
September 9th, 2025, 9 a.m. before me.
Your Honor, Mr. Scott wanted me to let you know that he is in a literacy program because he can't read. He wants the court to know that he is doing his best to fix that. He got a certificate.
It's in here.
It's in here, and he wanted the court to know that.
Did you just get it?
Yes, I just got it like a couple days ago. If you wanted to see it, I can't get it out in my hand.
Yeah, I understand.
It's the white one.
Yeah.
Nothing.
I mean, so you did this since you've been in the garage?
Yes, I have. I've been working on my reading and my writing.
And he wanted me to let you know he did complete the inpatient treatment program too.
And you did the inpatient?
Yeah, I'm doing what Slay had put me in the class. So
Judge Slay.
Yeah, Judge Slay had put me in I meant to say her name right, but Judge Slay put me in the class, and
that's okay. I just call it Slay.
Okay.
But you can.
Go ahead. That's all right.
Yeah, you don't.
All right.
All right.
So he wanted me to let you know that, Your Honor.
Congratulations.
Thank you. I gotta put that.
All the time I could have done that before this.
I know.
I know.
I've tried.
Hard headed.
It's kind of hard for me because I like hide that from a lot of people that I can't read that well.
But I've known it since probably the second time I saw you.
Yes, sir.
All right.
So we'll get it moving now.
Thank
Okay.
you. We'll see you in about 12 days.
Yes, sir.
Fine, we'll continue on this. Court does call the case of People versus Abdul Scott.
Folks for people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Scott, who is approaching the podium. State your name for the record, sir.
Abdul Scott.
Thank you, Your Honor. I have discussed these matters with my client, and I did reach out to Ms. Feltz. I almost said Ms. Londy, who indicated that she would have to check with the complaining witnesses regarding a potential resolution. So I would ask for an adjournment of both cases and to very, very briefly address bond when appropriate.
September 11th, 2025, 9 a.m. Go ahead.
I'm sorry, Your Honor. That was the 11th.
Yes.
Okay, thank you. Sorry. As to bond, Your Honor, I do acknowledge that my client did have a failure to appear in one of these files for PCC and wasn't warrant status when this new case came about. However, he is asking if the court would consider a reduction or release on both files. He does reside at the Delana Center and can bike to court. He's very apologetic to both me personally and to the courts for missing his court date, and he would like the court to consider a release.
Response.
Now we're in the Abdul Scott case, and this is where bond becomes critical. The defense is asking for release, or at least a bond reduction, arguing he can get to court by bike and that he's sorry for missing a date. But listen to the prosecutor. They're saying this isn't just a missed appearance, they're alleging two separate incidents. First, not returning about $7,400 worth of high-end camera equipment, which sounds like a rental scam. Second, a stolen purse with a passport and essentials from a movie theater. That's not small time. That sounds like risk. Here's the legal tension. Bond isn't supposed to punish you before trial. It's supposed to make sure you show up and don't reoffend. So ask yourself, with those allegations, would you have denied bond too? Or do you think he deserved another chance?
Your Honor, as defense counsel indicated, the second case did come up while the defendant was in bench warrant status on the first case. I think it's important the court to have a little bit of factual information. The allegations in the first case include the defendant failing to return about $7,400 worth of camera equipment to a camera rental place. And then second case involves the stealing of a purse, which had a passport and all the sorts of different things you might expect to find in a purse from the movie theater. So I'm concerned if he is out, what his behavior will look like. I ask the court to continue bond as currently set.
Motion for bond reduction denied. Bond will continue. Thank you. Court calls case People versus Winona Harvey.
Assistant Public Defender Chinazi Kariak, Your Honor, on behalf of Ms. Winona Harvey.
Harvey, can you state your name, please?
Harvey Winona. Winona Harvey.
Okay.
Your Honor, this matter is set for competency evaluation review today. Unfortunately, we have not received the report back from Forensic Center. I did reach out to them and they confirmed that we completed the evaluation on the 20th. And they just told us that we should be expecting the report.
Okay. They completed the evaluation portion. They just need to.
That is correct.
What's going on, Judge?
Pardon?
What's going on in my case?
What's going on?
Yeah.
Waiting for some paperwork from some people regarding you. Once I get that, we can move your case along, okay?
Okay.
Okay.
This is one of the most frustrating situations you'll see for a defendant. Competency limbo. We're now with Ms. Harvey, and the court is literally saying, we can't move forward until we get the mental health evaluation report from the Forensic Center. Translation, the system can't legally continue the case, can't resolve it, can't sentence it until she's declared competent or not competent to proceed. She's clearly aggravated, saying this is her 5th time in front of the same judge with nothing happening. And honestly, that anger is understandable. She's sitting in custody, being dragged back and forth to court. And to her, it sounds like paperwork is the only thing between her and progress. From a legal standpoint, though, the judge cannot advance without that evaluation. Due process requires it. Fair safeguard or slow motion torture.
Okay. So what I'm going to do is I'm going to adjourn this out. Let's go the 18th. If we get it earlier, we'll move it up. September 18th, 2025, 9 a.m. I'm sorry?
We're not coming for, lady. We come and take care, participate in something, or that's coming for no reason.
No, you're here for a reason.
I don't want to
You
go
have
back to my. I don't want to go back to my cell and have to come back down here again. So I bet this
You don't wanna go-
it's my fifth time in court with you, and you won't say nothing.
I know.
Nobody do nothing.
Well, that's because we're waiting on other people to do some work, because I can't make a decision or do anything until I get that.
Okay, sir. So what would you like me to do?
So I'm hoping the next time we have all of what I need. Okay?
Yeah.
All right. Thank you. Bond will continue.
Thank you, Judge.
Okay.
All right. You take
Bond,
care.
sir. What's bond? All right.
Your bond, it's gonna stay where it is right now.
Okay.
All right.
In this courtroom session, tensions rise as defendants face the judge with last-minute excuses, unexpected pleas, and emotional confessions. But the judge isn't buying all of it. He demands accountability, sharp answers, and respect for the law. What happens next is a moment no one in the room saw coming.
Yaki, Assistant Public Defender, with and on behalf of Mr. Sims, who's approaching. This side. Mr. Sims, can you state your name for the court?
Ronald Sam. Okay. What do you want to do on this?
Your Honor, I'm asking for a brief adjournment. As of yesterday, we didn't have all the media discovery, and so we need to adjourn to review that.
Without objection, probable cause September 11th on all matters, 2025, 9 a.m. Bond will continue. All right. Thank you.
I just don't have an exact date.
Gotta go. Whenever they're bring them out, court calls the case People versus Gregory Sistrunk.
Asheville, for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Sistrunk, who approaches, Your Honor. Please state your name for the record.
Gregory Sistrunk. All right, there's
Your Honor.
discovery you're waiting on.
Your Honor, I may have turned in a green sheet on that one. As far as I'm concerned, Your Honor, discovery is complete, and I am asking to set for a preliminary examination. I just checked in with APA Londy on that.
There may be one additional video in one of the cases. I'm going to reach out to fills out, but I understand the defendant wants to go ahead and be set, so we need one, and that's fine. We'll do our best.
All right, but there's one video. He understands that it won't get an adjournment if that video is not in.
Potentially one video, Your Honor. That is our understanding, and that is his understanding as well.
People have their witnesses available tonight.
We'll try now.
Preliminary examination in person will be set September 9th, 2025, 9 a.m. before Judge Valvo on all matters.
Thank you, Your Honor.
All right,
Thank you,
so,
Bond.
okay.
Case of the People versus LaDonta Skinner.
Stephanie Cannon on behalf of Mr. Skinner.
Your name?
LaDonta Skinner.
All right. What are we doing?
Your Honor, we're asking for his preliminary exam to be set.
Discovery is complete.
To the my knowledge, yes.
And would people have their witnesses available tonight? Preliminary examination in person September 9th, 2025, 9 a.m. before me.
Thank you so much, Your Honor.
Thank you. Bond continue. Courthouse case of the People versus Eric Smith.
People, Your Honor.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Smith, who is approaching. State your name for the record, sir.
Eric Smith.
Thank you, Your Honor. We're asking to set this case for a preliminary examination. To my understanding, Your Honor, my client is also asking me to make a request for a dismissal at this time. I did advise him that that is not yesterday at the jail, that is not something I can make at this time. However, we are requesting to set this case for preliminary examination and to address bond when appropriate.
The basis for the dismissal.
My client is asking for the basis of dismissal as he does not believe that he is guilty of the crime. I have advised him that that is not a valid basis for me to request a dismissal at this stage. So,
I don't need a response. That motion.
thank you, Your Honor.
It's time denied. He'll have his preliminary examination, then
Thank you, Your Honor.
court can make a determination. Will the people have their witnesses available on the 9th?
Yes, we will.
Right. Preliminary examination in person, September 9th, 2025.
Listen closely to the Eric Smith exchange because this is a classic courtroom moment. The defendant wants the case dismissed because he says he's not guilty. His lawyer is forced to explain in open court that I'm innocent. Is not a legal reason for a judge to toss a case at this stage. The judge has to see probable cause first in a preliminary exam. Also notice the bond fight. Defense asks for release on personal recognizance despite a prior failure to appear, and tries to frame that miss as a transportation issue after being told to come in person instead of Zoom. The judge's response, immediate denial, no debate. That tells you the court is signaling if you don't show up when ordered, even if you claim you couldn't get there, your credibility on bond is almost gone. Question for you. Should a missed court date because of no ride still count against you?
9 a.m., that is before Judge Valvo. Esteban, briefly.
Thank you, Your Honor. I do acknowledge that this case has been in bench warrant status since March of this year. However, Mr. Smith is asking for a release on a PR bond. Previously, that failure to appear, he
How
did.
did he come back into custody?
He did not turn himself in, Your Honor. I believe it was Trista.
I was at court on Zoom, and then he wanted me to come in, but I had no way. So that's how I come in.
That was from the failure to. So, Your Honor, as Your Honor would remember, my client would like me to state to the court, he had Zoom permission prior to the PCC back in March that he failed to appear to. He was on Zoom, then of course the new misdemeanor case, that complaint was authorized. Your Honor wanted him to appear in person. PCC, I advised him of that. He did not have transportation, did not appear. That being said, we are asking if he would be released today in his own recognizance. His misdemeanor case has a $1,000 10% bond.
I don't need a response. I'm well aware of the circumstances. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Colin Spry.
Ashley Felt is for the people.
This is about Defender Sandra White on behalf of Colin Spry.
Your name?
Colin Joshua Spry.
What are we doing?
Your Honor, we're asking for an adjournment. There was documents requested from CMH so that we can make a mitigation statement. I did receive a letter from them that they received our request. It did not indicate how long it would take them to.
You want the 18th or the 11th?
Let's try the 11th, Your Honor.
Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Derek Stevenson.
And Lori Gaggi, Assistant Public Defender, with and on behalf of Mr. Stevenson. I apologize. Oh, sorry, could you say your name for the court?
He's waving.
He is, Your Honor, and we do have an agreement from Ms. Willowbring as to a plea in circuit court for with no DOC.
All right, you want to state that on the record?
Yes, Your Honor. So I was in communication via email with Ms. Willowbring about pleading a plea in circuit court and the COBs that we would be seeking that the people would not object to in circuit court would be no DOC. No specific amount in terms of jail time, though. That's to be determined, but specifically no DOC.
All right. That's my understanding. All right. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, I do, Your Honor.
People do also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We would waive formal reading, Samuel.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
September 9th at 1:30 with Judge Cuskey.
September 9th, 2025, 1:30, Judge Cunkey. Bond continued. Court calls case of the people versus Sheena Stout.
And your Honor, Constable based on behalf of Ms. Sheena Stout. Who is approaching the podium to my right. Stout, can you state your full name for the record?
Sheena F. Stout.
Your Honor, today is the date and time set for probable cause conference. At this time, we're asking for an adjournment, and we're hoping that adjournment is on or past October 7th to coincide with the community corrections order that Judge Conkey gave her release to treatment at Bear River.
Is she going to Bear River?
Yes.
So
So
you need a date after October what?
October 7th.
2nd?
7th, Your Honor.
Without objection, probable cause conference, October 16th, 2025, not me. Bond will continue. Does she have a release to treatment out of this case?
I was going to ask for that, Your Honor, if appropriate.
Submit an order and get it in today so there's not a holdup when I'm getting to Bear River.
Will do.
Thanks. October 17th.
16th. Okay, sir. Court calls case People versus Devin Julia Martinez.
People, Your Honor.
Yep. Just can't, oh.
Stephanie Cannon on behalf of Ms. Martinez. Ms. Martinez, could you please state your name for the record?
Devin Julia.
Your Honor, at this time, we are going to waive our right to a preliminary exam.
All right, is that correct?
Yeah, it's also address bond, for sure.
I will ask to address bond when appropriate.
Just making sure.
You're waiving your right to a preliminary examination, Ms. Martinez?
Yes, sir. Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and if you committed them?
Correct.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Agreed.
Do you understand that?
Yes, I agree. I understand. I agree.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Thank you, Your Honor. At this time, we will waive formal reading of the information and we will stand mute as to charges.
Defendant having waived formal reading, standing mute as to both counts, court will enter not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Cuskey.
September 8th, 2025, 1:30, Judge Hamud.
And Your Honor, as to bond.
As to bond.
Thank you. My client, when I met with her, I think Tuesday, she wanted me to let you know a series of things. One is she does have stable housing. If possible, she does want to be released to treatment at Spera for mental health and substance abuse.
Spera?
Yes, to Spera. She wanted me to ask in this case if we could get a 10% contingency on her bond, maybe 10,000, 10%. She wanted me to let you know that at the time she was on Ativan, she was in the middle of a psychosis. But for that, this would not have happened. She wanted me to let you know she's working for the government. She has a stable job.
I just want to really fast interject. It was the hospital that put me on Ativan as well. So for record, thank you so much. Sorry.
No, it's not a problem. And she wanted me to let you know that she has a cat. She lives with her fiance who needs her help with rent. Her wedding had to be postponed because of all of this. She has family support, her grandmother, dad, brother, mother, godmother, and friends. Your Honor, my client is just asking for the ability to be released. She understands that there will probably be a monetary amount associated with it, but she was hoping for 10,000, 10%.
Now we're with Ms. Martinez, and this one is emotional. Her lawyer is basically building a full mitigation profile in real time. stable housing, a fiancé who needs her for rent, postponed wedding, family support, mental health crisis, psych meds from the hospital, and a request for treatment instead of just sitting in custody. She's even asking for a $10,000 bond at 10%, which would mean $1,000 to walk. Here's where it gets interesting. The judge denies the bond request, but then agrees to sign an order for inpatient treatment with personal recognizance, specifically for that program. That is a surgical decision. He's saying, no, you're not just going home, but yes, I will let you leave jail if it's directly into rehab under court control. That's a court trying to balance community safety with treatment. Do you think that's fair, or is it still too strict?
What I'm going to do, I don't need a response. I'm familiar with this defendant. I'm going to deny your request. I will sign a release to inpatient treatment on a personal recognizance. So I'll sign an order to that effect. But this time I'm not going to release it.
And thank you, Your Honor. And I'll talk to you about what that means, Ms. Martinez. Thank you, Your Honor.
So just for technical purposes, I'm denying your request. However, I will sign that order.
Technical purposes are understood. Thank you. I appreciate you, Mr. Simpson.
All right. Take care.
Good day.
Court does call the case, People versus Gary Taylor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Taylor who approaches. Mr. Taylor, can you please state your name for the record?
Gary Taylor.
And Your Honor, unfortunately, I do know that I don't have all the discovery in these matters, so I'm going to have to ask for an adjournment.
Oh, that right. There's also there's bond violation is why he's in custody at this point.
That's my understanding.
All right. We think can we get discovery cleared up in 2 weeks?
Yes, Your Honor.
All right. So I'll adjourn all of these cases to September 11, 2025, 9 a.m. Bond will continue.
All right, that'll allow us to review that, okay?
Thank you. Rude.
I do my best, you know.
Well, court calls case, People versus Cody Wines.
That's supposed to be people.
Bill BC.
Sorry. Listen, Public Defender Constable Basie on behalf of Mr. Cody Wines, who is present to my right. Mr. Wines, could you state your full name for the record, please?
Cody Michael Wines.
At this time, we're respectfully requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 9th.
Try. Thank you.
Preliminary examination in person will be set September 9th, 2025 at 9 a.m. I'm sorry, before
you.
Before me. I'm sorry. I don't know why I stopped at that point. I just did 9 a.m. before me on the 9th. Thank you, folks. Bye.
Thank you, Your Honor.
Today inside court, defendants tried everything: excuses, apologies, even emotional stories. But the judge kept full control, challenging every word and reminding everyone that justice can't be avoided. Watch closely because one shocking ruling changed the entire hearing in seconds.
Not signed in. I'll grant an adjournment.
Thank you.
He's fairly new to being admitted there, I think.
Yes. So I'm going to put it out a little bit to the 18th. Well, no, I'm going to put it 25th. And let's see exactly where he is.
9:25, Your Honor.
Yes.
I'll do a writ.
At 9 a.m.
Thank you, Your Honor. And I did reach out for what it's worth to the Forensic Center. I just hadn't heard back from them, unfortunately.
Okay. All right. Thank you.
Thank you for your lunch.
It's her.
Yeah.
He's not accepted back.
I don't know. I emailed him. These two are Spanish. This guy's going to be in Zoom.
So, court does call the case People versus Robert Gillette.
Douglas and people.
Assembled Lacey on behalf of Robert Galit, who's present via the Washington County Jail by Zoom.
You're going to need to, oh, there we go. Okay, state your name.
Robert Gallet, also known as Lynn, sir.
All right.
Your Honor, I'm also standing in for Mr. Kilowald on this case, on the other matter. So we're asking.
Do you have any objection to Mr. Belbisi standing in for Mr. Kilowald?
No, sir.
Pardon?
Not at all.
Okay.
Your Honor, we're going to be requesting an adjournment to confirm my client's getting into Avalon Housing so we can continue negotiations for an offer.
Got it. So
we have both I and Mr. Kilowald have reached out to Avalon to confirm the housing. We're yet to receive an answer. So we just need a brief adjournment.
September 11th, 2025, 9 a.m. Found continued. Thank you
so much, Judge.
Let's wrap what we just watched. Over the course of this docket, the judge kept drawing the same line. Responsibility. If you miss court and keep catching new cases, bond gets denied. If you're accused of new thefts while already on warrant status, bond gets denied. If you demand dismissal just because you don't think you did it, that's denied too, because legally the court needs a probable cause hearing first. But on the other side, when defendants show effort literacy classes, inpatient treatment, genuine rehab work, the judge is willing to work with them. We saw him congratulate one defendant on trying to learn to read, delay another case to confirm housing, and even sign off on structured inpatient release instead of straight jail. That's the real courtroom balance. Punishment risk versus rehabilitation potential. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.